Dear Justices of the Supreme Court of Nigeria, some of us have read the certified true copy of your ruling or your judgment in the case of Fubara versus the 27 lawmakers in Rivers State. In fact, the reports that many of the newspapers and media houses have is that, Rivers crisis, Nigerian Supreme Court explains judgment restoring Amaewhule-led assembly. But this explanation needs further explanations, particularly to lay Nigerians on the street. The Supreme Court is final in that outside the Supreme Court, the only person left to appeal to is God, which is not constitutionally recognized. But the question is this. In going through the ruling, there are some things that come up. For example, you say that there is no iota of... The court made it clear that there was no iota or shred of evidence to support the claim that 27 members of the House of Assembly had defected from the People's Democratic Party, PDP, to the All Progressives Congress. Dear Supreme Court, I need explanation, because are you saying that the videos that we saw, the event that took place in public glare, in front of cameras and broadcast across all Nigeria, in fact across all the world, showing the same Martins Amaewhule-led lawmakers openly defecting to the APC, and the open acceptance of the APC of these same lawmakers to the APC, the flying of the flag of the APC by this same Amaewhule-led 27 lawmakers of the APC in the State House of Assembly, all of these are not evidence that the lawmakers defected? Is that what you're saying, O Supreme Court? Or are you saying that the Fubara-led government did not present any of these cases to you in court? We need a clarification between these two positions. If, like it is claimed here, because you claim it is claimed here that to worsen the situation, the judgment signed by Justice Amaewhule revealed that the Rivers State Governor, Siminalayi Fubara, who raised the allegation of defection against the 27 lawmakers, later withdrew the allegation on his own volition at the Federal High Court. Could it now be said that your ruling that there is no iota or shred of evidence that any defection took place is based on the fact that there was no evidence presented to the court, or that Fubara, who raised the allegation, withdrew that allegation? Is that the reason why you insist that there is no defection, or that what we saw does not constitute evidence? I want to believe that you are saying that Fubara did not present any evidence, or that he withdrew the allegation himself. If that is the case, then you need to let Nigerians know. You need to clarify this before Nigerians, so that what people say in public can now be denied by them later. This brings to fore another issue. From the judgment itself here, by failing to substantiate the defection claims against the Amaewhule-led leadership, the Supreme Court held that In the eyes of the law, no defection had taken place, and consequently, the status quo in the House of Assembly must remain. Justice Ajim, who endorsed the judgment, specifically stated that there cannot be a House of Assembly except as prescribed by the 1999 Constitution. As a result, the judgment stated, what is clear from the above concurrent findings is that the eighth respondent, Fubara, initiated the prevention of sittings of the Rivers State House of Assembly, constituted by the numbers as prescribed by Section 96 of the 1999 Constitution, long before the issue of the remaining 27 members defecting to another party arose. The said activities of the eighth respondent, Fubara, were adjudged by the concurrent holdings of the Court of Appeal as illegal and unconstitutional long before the allegations of defection started. Against the background of these concurrent findings and holdings in the Court of Appeal judgment, it is reasonable to conclude that the cross-appellant's reliance on Section 102 and Section 109 of the Constitution and the doctrine of necessity is intended to continue his brazen subversion of the Rivers House of Assembly, the 1999 Constitution, and the legitimate government of Rivers State. Having, by his own admission, engaged in a series of illegal activities aimed at preventing the 27 lawmakers from participating in House proceedings and carrying out their legitimate legislative duties, his resort to Section 109 of the 1999 Constitution and the doctrine of necessity on the basis of his allegation that they have defected is a red herring to perpetuate his subversion of the Rivers State House of Assembly, the national 1999 Constitution, and democratic government in Rivers State. It would seem that the Supreme Court is making a categorical statement, not that the open declaration of defection of the 27 pro-Wike lawmakers cannot be evidence of defection. That is not what the Supreme Court is saying. What the Supreme Court is saying is this, that the case before the court is a case of the issues of the destruction of the State House of Assembly quarters, the prevention of the Amaewhule-led House of Representatives, and all of that. That is what is in question, not whether or not they defected. So as at the point where this case was brought, the House of the 27 lawmakers had not defected. So, and then to make matters worse, Fubara now goes and withdraws the allegations of defection, which were filed later. Nigerians should therefore get this clarification, particularly if it comes from the Supreme Court. It becomes clear that what needed to have been done would have been, instead of the state governor taking matters in his own hand and destroying the legislative chambers with all the actions it took, what the state governor could have done was go to court. In fact, not only the state governor, the PDP in the state or the PDP national should have gone to court to first of all say, oh, the lawmakers have defected, declare their seats vacant. If Governor Fubara had gone to court to seek interpretation of Section 109 of the Constitution before taking any action, the Supreme Court would not have struck out the case. The Supreme Court will not have dismissed his case. Nigerians, we need to understand this. Yes, it will help that the Supreme Court will clarify this, but we also must also try to understand that the ruling of the Supreme Court does not excuse or does not prevent the admittance of the open declaration of defection of these 27 pro-Wike lawmakers as evidence of defection. It does not prevent it. It just so happens that the Fubara-led state government put the cart before the horse. Instead of taking the appropriate action, they took matters or took laws into their own hands and engaged in illegal activities. It is the activities that led up to the point of defection that the Supreme Court is tackling. So if right now the 4 remaining House of Assembly members of the Rivers State House of Assembly, if they go to court now to say there was an open declaration of defection by these 27 lawmakers, and it takes the video evidence, and it takes the waving of the APC flag in the National Assembly, in the State House of Assembly quarters, and it takes the welcoming address of the APC, of these same 27 lawmakers into the APC in Rivers State. If these remaining 4 makers take this case to court now, I am sure that they will get a ruling to declare the case of the seats of these 27 lawmakers vacant. What we must understand in this ruling is that the Supreme Court is saying that the state governor cannot on his own declare that the seats of these lawmakers are vacant. That is the ruling. That is my understanding. It will help that the Supreme Court clarifies this. The Fubara-led state government took matters into their own hands and just began to act, refusing to give attention to the Amaewhule-led faction, refusing to destroying the state House of Assembly quarters and all that. These are the actions that the Supreme Court ruling actually handled. So we as Nigerians, we are seeking this clarification so that it doesn't look or sound as though the ruling or judgment of the Supreme Court is in this case is contrary to previously set precedents. Because from where I stand, it looks as though that this particular Supreme Court ruling simply states that things must be taken in due process, accordance to the way things happened. That's what it's saying. So let's not, and the 27 lawmakers should not now become puffed up and unnecessarily arrogant that they have got a ruling of the Supreme Court and that means they are untouchable. No. Another case, a fresh case can be filed on their declaration of defection. It can be filed by the PDP at this point or by the 4 remaining lawmakers. Yes, they can file and say, oh, there was an open declaration of defection. All the talks about whether they submitted or they did not submit or all that may not arise. In fact, if the PDP were to be smart, and this is the problem with many of our politicians, they don't act smartly or they do not think things through before they take action. This is what Fubara is suffering right now. When those 27 pro-Wike lawmakers announced publicly their defection from the PDP to the APC, what the state government would have done is go to court on that particular issue, not on presentation of budget, not on destroying the State House of Assembly complex, not on that. Go to court on that issue and say, court, Section 109 says this. These lawmakers have openly declared. Please declare their seat vacant. That's what the state governor could have done. In fact, the PDP could have done a smarter thing by saying, okay, even though the lawmakers have not tendered any resignation in writing to the PDP could have requested or ordered the lawmakers to retract their statement officially. You write to the lawmakers officially to say, lawmakers, this is what we heard. Is it true? If it is true, we give you 24 hours to write us officially to say that it is not true. Else, further actions will be taken against you. If the PDP had done that, then there would have been evidence against the lawmakers. Had black and white evidence, but they didn't do that. The other 4 remaining House of Assembly members, the Oko-led, I don't know his name now, he could have also gone to court to seek interpretation of Section 109 of the Constitution. But they didn't do that. They just, out of their own volition, now started acting. This, in my opinion, is what the Supreme Court is trying to correct. Not that the action of the 27 lawmakers led by Martins Amaewhule is right to declare defection in public. That is not what the Supreme Court is trying to defend. And we Nigerians must begin to learn how to present our cases. We must understand the rule of law. We must understand due process and act accordingly, even when we want to seek redress from rule of law or from due process, because, of course, he who comes to equity must come with clean hands. So, O Supreme Court, it will do Nigerians a whole lot of good if you will clarify this position, that your ruling, the Justice Judgement-led ruling, is not based off, it's not trying to legitimize open declaration without formal submission of resignation. We need this clarification. So if you can help us with this clarification so that Nigerians can better understand that it is the way the state government handled it that you were trying to correct, then Nigeria will be better for it. And in any case, the 4 remaining House of Assembly members and the PDP must now come out and take legitimate legal action. Right now, where do these 4 lawmakers stand? I would have expected that going forward, what the PDP should have done, even right now, is call those 27 lawmakers, call the 27 lawmakers, the Martins Amaewhule-led House of Assembly in Rivers State, call them and ask them, oh lawmakers, this video of you is all over social media, and it shows you saying that you defected to the APC. In fact, there are videos that also show you waving the flag of the APC. Is it true that you did this? If it is true, that amounts to, is it true that you did this? So you give the lawmakers the opportunity to respond to that, because right now, there is no clear definition of where these lawmakers stand. They appear on paper, going by this ruling of the Supreme Court, to be members of the PDP, but publicly their allegiance is to the APC because their master, Wike, serves at the pleasure of Tinubu, that is the leader of the APC. So the PDP needs to take steps to call the allegiance of these 27 lawmakers to question by writing them officially and asking them to officially write a response to state where their loyalty lies. And when this happens, you can now go to court and say, or you can now take a decision and say, no, we are not satisfied by your response. This action that you took, this action that you took, this action that you took constitutes anti-party activities. And therefore, we hereby dismiss you from the party. When that is done, the seat would also now, the party can then go to INEC and go to court, first of all, to say, lawmakers have been expelled from the party through a due process of disciplinary actions where they are called to defend themselves and the evidence are meted out against them. And then a decision was reached by the disciplinary council, and consequently they were expelled from the party. Based on that, Section 109 should now be interpreted by the court. Once that is done, then you can now use that to go to INEC and ask INEC to do a rerun of election. This is the smart way to go, legally speaking, that the PDP can still follow, that the 4 remaining lawmakers in the Rivers House of Assembly can still follow, that even Governor Fubara can still follow. Instead of all this unnecessary fear of impeachment. After all, the impeachment needs the support of the Rivers State High Court. Yes, according to law, it needs the support of the Rivers State High Court to conclude. So this is the legal option that Fubara still has. All these, call them, look at now. He has called them, they have refused. So what does he do? We must learn a lesson as Nigerians. And the crucial lesson that we must learn is this. In all of this back and forth between or among our political leaders, it is clear that none of them are acting in the interest of Nigerians. Everybody, all of them are acting first in their own primary interest, even before party interest. Because when you have an Amaewhule-led House of Assembly that is loyal to Wike, that is a crime. You cannot come out to openly declare that your loyalty is to a person when your loyalty should be to the state governor or to the constitution of Nigeria. That is a breach. And we must also now take this up with the people.